Be seated. We move to phase 2 of the oral argument. Mr. Griffin, are you going to be arguing the evidentiary issues?
I am, Your Honor.
We're ready to hear from you, sir. And good morning.
Good morning. Thank you. Chief Justice Kittredge, members of the court, I'm Jim Griffin. I'm here representing the appellant Alec Murdaugh. This appeal presents 5 fundamental evidentiary errors that individually and cumulatively denied Alec Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified and knew nothing more than anyone else in the courtroom. 2, the court admitted gunshot residue evidence from a blue raincoat, despite the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket. 3, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years, the crimes that were committed by the appellants. 4, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges. And 5, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself could not state to any reasonable degree of certainty during the counsel hearing. In the interest of time on that 5th issue, I intend to rely on the briefs unless the court has any questions about that evidence. The evidence in this case did not conclusively prove defendant's guilt such that no other rational conclusion could be reached. Therefore, none of these errors were harmless beyond a reasonable doubt. There were no eyewitnesses to Maggie and Paul's murders. The murder weapons were never found. The forensic evidence does not support Alec's guilt. All crime scene criminologists, experts testified that whoever shot and killed Paul shot him in the head, his brains hit the ceiling, and blood and brain matter would have been on the guns and on the shooter. That was without a doubt. And there was no brain or blood matter found on Alec's person, his clothes, inside his Suburban, inside his home. They checked the bathtubs, nowhere. There were trace amounts of DNA found on Alec's clothing that were consistent with his explanation that he checked them for signs of life. There was minimal GSR, gunshot residue on Alec's, which also was consistent by the SLED's own testimony, consistent with him going back to the house, getting a shotgun for personal protection, and waiting for law enforcement to arrive. Alec Murdaugh's interactions with others after he left the kennels that night and before he returned and called 911 was normal. He talked to his son Buster, he talked to his brother John Marvin, he talked to another lawyer, Chris Wilson, about the case. They all said his demeanor was normal. Visiting his mother, there was nothing out of the ordinary about his demeanor. There's no time of death established. The coroner did a finger test under the armpit. The state relies exclusively on cell phone data inside the phone to establish a time of death, which was unreliable in our opinion. The cell phone data showed at 8:45 p.m. there's a kennel video. And Alec had lied about previously in his interviews about being at the kennel with his family. But there's a kennel video at 8:45. There's nothing on the video that would lead someone to believe that there's a murder about to happen. It portrays a normal family. At 8:49, Paul used his phone for the last time. It had very little battery left on it. At 8:55, there was some action on Maggie's phone. And at 9:06, Maggie's phone registered movement for the last time, some 20 minutes after Alec testified that he left the kennels. We submitted an expert on acoustical testing, and it was uncontradicted that if you're in the house with the door closed and the TV on, air conditioner on, you could not hear gunshots down at the kennels. And then Alec's testimony himself denied killing his wife and son. So this was not an overwhelming evidence case. This was a very close case. And the cell phone and GPS data, frankly, pointed to his innocence, not his guilt, as as I will explain in a moment. And that brings me to the first issue that I'd like to address, is that the state was allowed to present expert opinion testimony about a test that was done during the middle of trial from a cell phone forensic expert, a deputy from Charleston, who had previously been testified about chain of custody and other issues, that during the weekend after our expert testified, and it's critical to know that Maggie's phone was found on the side of the road about a quarter of a mile down Moselle Road and 15 feet off the side of the road. And when we finally got the GPS data during trial from General Motors and the OnStar data, Alec went by that location doing 42 miles an hour at 9:08 p.m. As I mentioned earlier, Maggie's last phone activity, when orientation change in the phone, was at 9:06. The question is, if Alec had thrown the phone out at 9:08, would it have registered an orientation change? Would there have been anything in the phone to record him tossing the phone out? And the testimony that the defense presented was, Mika Sturgis talked about the rise to wake feature. He did an in-court demonstration. I was going to bring my phone up here, but if you lift it up, it lights up. All of us have.
What's your theory as to when the phone was tossed out of the window of by someone? What does the timeline show? I take it your argument is that when you toss the phone, at some point it's going to the raise to wake feature will activate. So my question is, on the timeline that we have, and it's extensive,
Right.
What is your theory as to when the phone was tossed?
So, Justice James, with all due respect, I want to rephrase it. I think that's asking the wrong question.
Okay.
I think the right question is, would the phone turn on and record any sort of activity if Alec threw it out the window at 9:08?
Yeah, I know you say that, but I'm talking about in the timeline that we have and the cell phone extractions that we do have, when was the phone tossed?
Well, the state's, so you could say one explanation, it was tossed at 9:06, because that's when it registered. Or you could say at 9:06, it was down at the kennel. Well, we don't know. Honestly, we don't know. We don't know how it got put on the side of the road. There's no witnesses. But what's so critical to our defense is that at 9:08, when Alec Murdaugh goes by that exact same spot at 42 miles an hour, if he had thrown the phone out the window, what would have happened? And the state says they were just replying to our expert, Mika Sturgis, who said he's not qualified to say whether the light would come on or not, whether it would register anything.
Similar question. I don't think you have to have a theory. That's the state's burden. But when we're looking at your argument that Alec didn't throw the phone out when he drove by because it didn't light up, that raises the question of how it got there. Somebody put it there.
No doubt.
And it never lit up. So the point that you're making is it's wrong for the state to be able to prove that it might not light up, but to me, it looks like it definitely didn't light up, because whoever put it there, unless it was at 9:06, the phone did not light up. So I'm raising the question of whether this even makes any difference.
Well, it makes tremendous difference, because if Alec threw the phone out at 9:08 when he goes by that location, our evidence, not through our cell phone forensic person, but through our accident reconstruction acoustical guy, Mike Sutton, with Accident Reconstruction Institute in Raleigh, North Carolina, says that phone at 42 miles an hour will tumble. And when it tumbles, that raised to wake feature. So we did put in the evidence through two witnesses, both qualified, about what they testified.
I got that, but let's just hypothesize that Alec didn't do it. He didn't have the phone in his hand when he rode by at 9:08. Somebody came along at 9:20, these roving marauders, you call them, or whatever, and they killed the Maggie and Paul, and then they were responsible for getting the phone to where it ended up. Wouldn't the phone have lit up then?
It depends on how it was placed there.
If we don't know whether it would have lit up then, we also don't know whether it would have lit up at 9:08.
Well, here's
That's
what,
why I'm asking why this even makes any difference.
here's what we know at 9:08. Alec car is going by that spot at 42 miles an hour. Did the Marauders go by and pull over?
Maybe.
Were they walking? I mean, we don't know. There is no evidence in the record. What there is evidence in the record is he went by that spot at 42 miles an hour, didn't slow down, didn't speed up, and if he had tossed the phone out, it would have tumbled, and all it has to do is go upright, and the rise to wake feature would come on, and so what, to combat that, they had a guy sit around the weekend throwing a phone around his office from
But
Friday
you
and Saturday.
cross-examined him very thoroughly, and said, he said he recorded nothing about his experiment. He wasn't an engineer. He didn't know more than anybody else, and he didn't testify to anything you couldn't look up on Google. So what's the harm in that? I mean, your cross-examination seemed to be very effective.
Well, the harm is the expert opinion he was allowed to express that says it was possible that the phone would not illuminate if thrown from a vehicle going 42 miles an hour. The harm was when Mr. Waters gets up in this closing argument and says, Paul Murdaugh got up here and testified as to the issues and to the fact that there's no guarantee, in fact, more likely than not, if the phone is violently thrown or flipped out or whatever, it's going to light up. I mean, that was critical to their defense to address, our exculpatory evidence that we went by there at 42 miles an hour, and if we had tossed the phone out, it would have shown something. If they wanted to test that, they needed to put an expert in a car doing 42 miles an hour, throwing it out the window, and then checking the phone to see what happens, and do it multiple times. But you don't sit around in an office as if you're playing cornhole with a beanbag all weekend, and then come to court and say, sometimes it lights up and sometimes it doesn't light up. And therefore, I conclude that, it's more likely than not it wouldn't have lit up if Alec Murdaugh went by there at 42 miles an hour.
This is certainly an unconventional moment at the trial, and, I was reflecting back on 10 years of trying cases, none of which were 6 weeks long. And, in the state's reply, everybody's tired, everybody's ready for the case to go to jury. It's almost like there's this unwritten rule of evidence that at that point in the trial, you can pretty much do whatever you want. But the question is, what did they do? And you're saying, when they stood up to speak to Judge Newman, they said, we got an expert. In their brief, they talk about it simply being an experiment. Judge Newman listens to all this, and he calls it an experiment. He doesn't call it expert testimony. He says, page 6721, he did not provide scientific testimony. He conducted an experiment and told the jury about it. And I'm just wondering, do we really need to go through a 702 analysis here, or should we be talking about the admissibility of an experiment?
Well, I believe this court's opinion in State v. White in 2009 that Justice Kittredge wrote, there's no distinction between, it's an opinion testimony.
Well, that was an opinion. That was an opinion based on the work of a drug dog.
Right. So, and here we have an opinion testimony that when Alec Murdaugh goes by that location at 42 miles an hour, the light may come on, may not come on. More likely that it won't come on. So that's the opinion testimony. And that is, whether it's scientific or experience, it doesn't matter under the analysis. But it had to be proven to be reliable, and it wasn't.
Mr. Griffin, I'd like for you to address the 404B issue, if you don't mind.
Yes, sir.
Do you believe any of the evidence about the defendant's financial crimes could have been admitted under 404B as motive evidence?
No, not a bit, Your Honor, not as motive evidence.
And I have some questions, I'm sure we all do, for Mr. Waters in terms of the expanse that was allowed under 404B. But what about like Ms. Seckinger's testimony, for example, on the day of the discovery of the theft of the Ferris fees? What about the impending motion to compel hearing in the so-called boat case a few days later that would have arguably exposed the extent of his financial misdeeds? Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seconder said that on June 7th, she went to confront Allett about, this Ferris fee. Now, understand this Ferris fee is a one-off situation from all his other scams and schemes. This was attorney's fees that were due to the law firm that he diverted to himself. That's the Ferris fee. And that's what was their concern, and her testimony was they weren't concerned that he was stealing money from the firm. They were concerned that he was hiding money from civil discovery from the boating case, and they didn't want any part of that. She also says when she's in there talking to him, he gets a phone call. They put his dad back in the hospital, and I took my CFO hat on, and I put my friend hat on, my mama hat on, and I started comforting him, and that was the end of it.
So until the moment of the call about the impending declining health of the father, we're in the motive territory. But once the urgency was removed by that phone call, it somehow's off the table?
I still don't think it's motive, because what the cases cited by the state and any case that you look to, for motive, it has to, and the cases that admit these type evidence in a murder case, is that the person murdered is either the victim, the person murdered is a threat to report the crime, the person murdered has life insurance, or the murderer is bound to benefit financially to get himself or herself out of the financial hole. I mean, none of those typical motive issues are present. What was present is this claim of sympathy, which in West Virginia v. McGinnis, and that really is the closest case that we can find about this, Your Honor. I mean, they reversed a murder conviction for letting extensive financial crime evidence and other information in, and I would read to Your Honor the conclusion from the court in the West Virginia Supreme Court. It says, the cumulative admission of the evidence under 404B, however, presents us with a likelihood that the jury convicted the defendant because of his character and not because of the evidence surrounding the murder. In these circumstances, these errors cannot be regarded as harmless. And you can't just piecemeal it either. I mean, there were 10 witnesses over 6 days, 38 transactions.
Was there any 404B evidence that was proffered by the state that was disallowed?
No, Your Honor, not that I can recall. And then, so you have 404B analysis and you have 403, and really the unfair prejudice just by the weight and the extent of that evidence, the sheer volume, 38 transactions, $9.97 million, 10 separate witnesses. In State v. James, I know it's a little different because State v. James involved prior burglary convictions with an enhancement, but the conviction was reversed where 7 burglary convictions were admitted when they only required 2, and they were limiting instructions given, and the court said that was it was not harmless error when you pile on that much, and this was piling on.
Let me ask you a question about the legal point of whether there's a logical connection or some logical relevancy, using the language our cases have used. I mean, you make a lot of good arguments that it makes no sense. Like this, he would never have done it for this reason. And obviously those arguments are in part, at least, for the jury to iron out, right? I mean, you made them to the jury and that they decide whether this makes sense in terms of a motive. But what I'm asking is, to what extent does the trial judge, when looking at a theory of motive that isn't 100% solid, to what extent does the trial judge analyze the believability, the ultimate usefulness of the theory of motive before admitting the evidence? Just to continue a second, in Lyle, we said that the trial judge has to clearly perceive the connection. Right. In Perry, we of course quoted that, but we also talked about the trial judge using a rigid scrutiny. I mean, really, in Lyle and Perry, though, the question was not the existence of a logical connection, because in Perry there clearly was one. I mean, in Lyle there clearly was one, and in Perry there clearly was not one. At least the majority said so. But in both cases, the real question was unfair prejudice. And I'm just wondering if this idea that the motive theory doesn't work is really a question of unfair prejudice as opposed to a question of logical relevancy.
Well, it's both. You have to do both analysis. Chief Justice Kittredge asked me if it was motive evidence. I don't believe it is motive evidence. It's certainly unfairly prejudicial under 403, and I was, to answer your question, Justice Few, I was about to cite to Lyle, the standard in Lyle, which is a very high standard. And what you have, and I think it should require, and I believe the law makes it require, more than a prosecutor's best theory. I mean, there has to be some evidence to support it, and it has to be like a life insurance policy, a windfall, things of that nature.
Or I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle on him, instead of,
That's right.
according to you, too many degrees of separation of murdering his wife and child.
Well, if there was evidence of that, and that's in the case law, yeah, if there were a threat to report, for sure. But none of that exists in
Was there any evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
I believe she perhaps
I mean,
had.
was there any evidence that she
Yes.
was going to confront him about money?
None whatsoever. None whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him hoarding pills?
No, Your Honor. It was only his drug use Paul was aware of.
I want to branch off for a moment. On page 6,340 of the record, Mr. Waters was cross-examining Mr. Murdaugh. And if you read it, it is very, very compelling cross-examination. Of course, Mr. Murdaugh's on the stand, so his credibility is in question. Let's assume that this financial crimes evidence came in reply.
Right.
Because a series of questions that Mr. Waters asked Mr. Murdaugh was, you lie, basically suggesting he lies with ease.
Correct.
Seamlessly lies about everything. Did you lie to your brothers? Did you lie to their wives? Did you lie to Marion Proctor? Did you lie to Bart Proctor? And all these answers were yes. Did you lie to the Brandstetters? Did you lie to Chris Wilson? Did you lie to them about the kennels? Did you lie to Mark Ball? So when his credibility comes into question then,
Right.
could this financial evidence have come in reply? I know that's not what we have here, but
Right.
Doesn't it kind of open the door, or maybe you would have chosen not to put him on the stand had the financial stuff not come in initially?
Well, there are 2 points with that. One, I don't think we cited case law that we don't waive our right to challenge that by
Right.
putting him on the stand
I
to
get
address
that.
it.
I get that.
But to answer your question specifically, under 608B, Your Honor, you are not permitted to put in extrinsic evidence of these things. You can ask him about it, but you can't then take 6 days and 10 witnesses. I mean, you ask him the question, and if he answers it, you got it. If he denies it, you're stuck with it. That's what under 608B. You're allowed to cross-examine him, but you're not allowed to introduce extrinsic evidence.
What if the questions had been more expansive? Did you lie to your partners about not stealing $9.7 million? I mean, it becomes, it's a different dynamic, I understand, but what I'm trying to search for is, would this have come in anyway?
Well, I do believe under 608, it's fair ground for cross-examination on his credibility. But then you get the 403
with his
analysis.
answer.
Excuse me?
You're stuck with his answer, which would have been
Right.
yes.
Yeah, but you don't get to then start putting up 10 witnesses to prove something that he's admitted to.
You get a new trial is coming in, but it's only, at least under 608,
If he testifies.
if he testifies. And in that event, you get another limiting instruction that says you can only use this to analyze his credibility.
Correct. Thank you.
I think this question's about.
Oh,
Wait a minute, we're just getting started.
About the weapons?
Yeah.
We have a question. We want you to argue about the admissibility of the weapons that were seized and introduced that were from Mizell.
yeah, so, in the weapons that were introduced in the evidence that were seized from the home, there was no testimony from anybody, even their.
Well, it's beyond that. The experts admitted that he could not identify it as a murder weapon.
Well, he said he couldn't include them or exclude them. And so, as we said, these guns, we know nothing more about them today than we did, any other day. Yet they were allowed to put those in the evidence. And we've got State v. McConnell and another case where I think McConnell, where they put .22 caliber bullets in evidence on a shooting case. And the person was shot and killed with a .357 Magnum. And that case was reversed. There was another case that we also cited, lost my place in my notes, but that.
What was the purpose, as you understand it, for the admission of the weapons that were seized from Mizell?
To prejudice Alec Murdaugh. I mean, that was the purpose. It made nothing more relevant or not relevant. I mean.
Didn't you suggest, though, that the police who investigated this had failed to do a complete job, and in particular, that they had failed to properly seek out and find the murder weapons?
Absolutely, and that stands
And wouldn't
today.
wouldn't a simple response to that suggestion be, we looked at every 12 gauge and 300 blackout weapon on the property, and here 4 of them.
Here's pictures of 4 of them, but you don't put them into evidence. You can have Greer testify, I tested all these guns. I don't know anything more about them today than I did yesterday. I can't include them or exclude them. That testimony is perfectly appropriate. But
After they were put into evidence, were they ever used or referenced again, touched again?
Absolutely, the Attorney General picks it up, holds it up, pretends that he's shooting somebody. He picks up the 300 blackout and reenacts the crime. Mr. Kinsey used them.
Well, they can be used for demonstrative purposes. You just object to them going back into the jury room. Is that what you're saying?
We did object to them going into evidence, for sure. And they could have had a demonstrative exhibit to demonstrate to the jury, but that's not what these were. These went into the jury, and they did an in-court reenactment with them.
Mr. Griffin, I interrupted you a little while ago to segue to the 404B issue, and I think you were either at or near the conclusion of your argument regarding the cell phone experiment.
Correct.
And if I cut you off, I didn't mean to, and I want to give you an opportunity if you want to finish any thoughts you had on that issue. It seemed very important to you, and I want to give you that opportunity.
I was done with the cell phone. I was going to go to the blue tarp and then the Doyle v. Ohio issues, but I'll rely upon the briefs, and Mr. Barber may be able to address it on reply. But I'm happy to stand up here and answer any questions about those issues.
I got a question about the cell phone.
We have a question.
Help me out here. The evidence was Mr. Murdaugh didn't use his phone from 8:09 to 8:40 something, 8:50, maybe 9 o'clock, right?
Right.
Which was unusual for him, according to the evidence. What does it mean in the testimony of the cell phone extraction witness when a call was in the Verizon records, but not on Mr. Murdaugh's extraction? What does that mean? There's a series, I made a series of notes. This call was not on his extraction. It was on Maggie Murdaugh's extraction, but not his. 905 calls Randolph, not on extraction. Does that mean that the inference is that he physically deleted it on his phone?
I believe so.
And there were probably 10 or 12 or more phone calls that were deleted, if
Right.
that's what the explanation is about not on his extraction.
I believe that is the case, that the information was deleted from his phone for some reason or another.
And this goes to circumstantial evidence of something, that he deleted the call. Was there any explanation at trial from your side, not that you were required to give one, as to why those calls weren't on his extraction?
There's no testimony about that at trial.
Okay, all right.
I have thoughts about that, but it's not in the record.
All right.
Justice Hill has a question.
Maggie's phone did not record steps at the
Right.
time, and you make a point about that.
Yep.
But also the location data got overwritten. Did that override the step data too?
That did not override the step data.
Okay.
And that was maintained in a different place, but the GPS data is pinging constantly, and there's only so much room, and SLED did not put that phone in a Faraday bag, which I didn't know what a Faraday bag was before this case, but they give them away at conferences, so it's not unique.
Thank you.
All right, no further questions.
Thank
Thank you so much, Mr. Griffin. Appreciate it. Yes, sir, Mr. Waters.
Thank you, Chief Justice, and may it please the court. I'll start out by saying, and again, I'm not going to, unless this court would like me to go through the extensive facts that were presented here, but fundamentally, our case boiled down to 4 important points. Number 1 was motive, and I know we'll talk about that, and I believe that the motive was very compelling here, and we'll go into that. But the motive pointed to Alec Murdaugh. Number 2 was the means to commit this crime. And what the evidence showed were 2 family weapons were used to commit this crime, both of which could not be accounted for after the crime was over with. Number 3, opportunity, and this was huge. That timeline that was very detailed, that frankly the defendant tried to use to be exculpatory, actually was very inculpatory, and showed that not only was he at the crime scene with the victims just moments before they died, but importantly had been lying about that to anyone who would listen. And that evidence was particularly strong when you look at the fact that when we look at that kind of evidence, we look at patterns. And what was also so important about him being there is that his phone showed no activity, as Justice James mentioned, from about 8:09 to 9:02. And then from 9:02 to 9:04, he had 283 steps, far, far more than he ever had in any comparable period during the review period that we had. So you had that evidence of opportunity showing that he was the one who had the opportunity to commit these crimes. And then finally, you had multiple acts of guilty consciousness of the various things that he told law enforcement and all the rest of it. So that's classic case. It may have been a long case and put it all together, but it boils down to basic, good old, how do you determine who did somebody? Motive, means, opportunity, and acts of guilty consciousness. And I think the evidence was very strong with all of that. We started with the cell phone evidence, and I'll go to that as well, since that's what counsel started with. And I want to start out by saying, first of all, that this is clearly not preserved. I'm going to talk about that very briefly because, as Chief Justice Kittredge pointed out earlier, this was an old-school judge. You got old-school lawyers, old-school prosecutors, and Judge Newman made it very clear at the beginning of this case what he expected with objections, that they be timely and that they be specific, okay? So this is not a case where preservation is a gotcha moment. This is a case where the judge was very clear about what he expected with that, and the parties that were trying this case are ones who understood that very well. So I think if there's ever a case to look at error preservation issues we've raised throughout this brief, this is that case to do that. But beyond that, let's look at what happened during the defense case. They called an expert who, Mr. Surgis, who is a former North Carolina deputy who has digital forensic examiner training in Cellbrite and Apple, and he was qualified in cell phone forensics. And while he was on the stand, he used an unidentified iPhone with an unidentified iOS operating system to demonstrate for the jury that just a general motion will cause the raise to wake feature to turn on. And they emphasized that over and over again, that all it took was a gentle motion. Just a gentle motion is all it took. And they did that demonstration on the stand. And so the state, in reply, called a deputy who had extensive training in digital forensic examination, same exact training, who was qualified without objection in the same exact cell phone forensics. And what was more important here was he was here to correct fundamentally what was a misleading statement from the defense examiner, because what he knows, and he knows how these things are programmed, he knows how they work, and the implication that if only a general movement will turn it on, that necessarily a more violent one, like slinging it like a Frisbee, will turn it on, is false, because the phones are designed and programmed, the accelerometer in there are programmed so that while a general normal motion when somebody wants to look at their phone will trigger it, violent motion will not, so that your phone's not constantly coming on when you're jogging or running or doing anything like that. People don't look at their phone like that, okay? And so the phones are designed to do that. So he did the exact same thing that the defense examiner did, except for he did it much better, because first of all, he used the exact same model iPhone. He used a similar iOS version that was used, and he manipulated it multiple times in many different categories. And it was there to ultimately disabuse the notion that if it comes on gently, it necessarily is going to come on when you sling it, because it just doesn't. And that is how iPhones work. And so when he was in cross-examination, and Mr. Griffin did a great job of cross-examining him, and at one point he says, well, I don't know anything about anybody else. Well, maybe that was an inopportune answer, but that's not the end of it, because he went on after that to testify, I have expertise in how cell phones work. I can tell you about the knowledge C databases. I can tell you the ways iPhones, the software is written, what kind of code it's written on, and I can tell you how data is stored on it and the program that's involved in it, the programming that's involved in it. And frankly, his testimony proves the point, because he made sure that the jury understood that just because a gentle raised awake, a general motion will trigger the raised awake, doesn't mean that a violent motion will do that. In fact, it's more likely that it won't, and the phones are designed specifically to do that. That is an expertise that is beyond the knowledge of the average person. And again, this is not one, I think, as we talked about before, where you need to apply the counsel factors and all the rest of it. When you're talking about sort of an experiential type of testimony, the ultimate test is reliability. And he had the same exact qualifications, the same background, and was qualified in the same manner.
But his testimony was, sometimes it does, sometimes it doesn't.
That's correct. And that's the reality of how it works. Because again, these things are programmed to react to different types of inputs, and it's not an absolute guarantee. But the point that was important about that was that just because a gentle motion might turn it on doesn't mean that a violent one would. In fact, it's more likely that it won't, because the phones are programmed to do that, and like throwing it like a Frisbee.
This is probably not relevant to much, but why this phone being taken from the scene, and why not Paul's? Why not just leave hers there too?
Well, that's very interesting.
Was there any, I know, is there evidence, I think there's evidence that it was raised to wake at some point and put back down.
Yes.
And that was at 9:02, 9:04, something like that?
Correct. So the evidence, if you look at that timeline, and I could go into it in great detail, but what the evidence showed and what the reasonable inferences from it was, number one, Alec had Maggie's passcode. He did not have Paul's passcode.
You might need to stick closer to the mic.
I apologize. All right. So he did not have Paul's passcode. Paul's laying face down, and his phone is laying just on the outside of his rear end, outside of his pocket. And in fact, the defendant told police that he picked up the phone, or he tried to turn Paul over, and the phone just popped out. Okay. But what's interesting about that is what's so crucial about the time of death and the forensic timeline, as we called it, establishing that time of death, is that Paul was actively in a conversation with his buddy, Rogan Gibson, and that's who the kennel video was for. But he never completed that conversation, and both Paul and Maggie's phone go silent forever and ever, amen, at 8:49, about 30 seconds apart. Well, Rogan continues to try to contact Paul, all right? And so when we look at contact on Paul's phone, there's somebody who actually looked at it, and the backlight came on, which is indicative of somebody, the Face ID, not recognizing who it was. But as we know, those phones will display like messages coming in. And very interestingly, Alec Murdaugh, in the wake of the brutal murders of his wife and son, yeah, he calls his brother, but then before he starts calling all these other family members, he's blowing up Rogan Gibson's phone. Okay? So the inference is that he saw that, he can't get into Paul's phone, but he's concerned about Rogan. The other inference is that he takes Maggie's phone with him, because we see steps on her phone, and we also see activity of the orientation changing, and that orientation will only be logged if the backlight is on. And so when he gets back to the house, that's all of a sudden when his phone comes alive. From 9:02 to 9:06, there are 283 steps, but at the same time, we're seeing orientation changes, and he is calling Maggie's phone. In fact, we can see an orientation change 2 seconds before the call comes in, which is certainly susceptible to the inference that whoever's calling is looking to see that call come in, like somebody who's manufacturing an alibi, like somebody who tells the police in his first interview, look at my phone, I was calling Maggie. He calls her multiple times while he is running around like a chicken with his head cut off, and then jumps in the car. And even though he said that Maggie came home because he asked her, or she was worried about him, and Marion Proctor testified that Maggie came home to go visit Miss Libby, after all of that, and he's blowing up her phone, he doesn't take the 100 yards down to the kennels to drive by there. So again, not to argue the facts, but all of this was very indicative when you look at this timeline of Alec looking at Paul's phone, leaving it there, taking Maggie's phone, taking it up there, start manufacturing, making sure those calls are coming in, and then as he's leaving out in a haste, he's leaving out of the Moselle, slinging the phone out on the road. And the reason why the backlight, there wasn't an orientation change for that is because the backlight didn't come on, and that was the point of McManigle's testimony.
I'm not asking you specifically, I want to change gears to 404. I'm not asking you specifically in this case, because I know you believe your motive is very plausible. But in general, how plausible does motive have to be? I mean, could a prosecutor want evidence in and work backwards from there? How does a trial judge analyze that?
Well, I think that the trial judge is fundamentally the gatekeeper and ultimately has to analyze that under the 404 test, which is it relevant? Is it fall under an exception? Is there a logical connection? Is it clear and convincing? And is it, the 403 analysis? I think that.
So not just the evidence you're trying to admit as motive, but the motive itself has to go through a 404 analysis. Is that what you're saying to me?
Well, I'm saying that the evidence that's being presented, every bit of it, yes, has to go through that and be part of that 404 analysis. But I think here, and I'll talk about this, that there's an unbroken chain, and that's why the extent, which it was extensive, but there's a reason why, and it wasn't overkill, it wasn't cumulative. But yes, the trial judge is absolutely the gatekeeper for that. Now, what we did here, and I think this is the best practice, is we wrote a detailed pretrial motion and laid it entirely out, wrote out every bit of it, wrote out the entire theory, and put that out for the defense and said, Judge, defense, this is what we're planning on doing. And in opening, I was very careful. I just said there's going to be things going on in his life. I didn't talk at all about that. And then we did the in-camera hearing, and we were very careful. And before I even broached those subjects, I raised that to the trial judge to ensure that the entirety of that was being considered.
Was there any 404B that was disallowed?
There was. So there was 404 of evidence of an affair that Marion Proctor and Maggie's concern about affair that he excluded as too remote. And then there was a side of the road and narcotics evidence, but ultimately that eventually came into play because of opening the door.
Was there any 404B related to financial crimes that was disallowed?
I think no, but I think that
That's what concerns me, and I want to just gently push back and give you an opportunity to respond. Yes, the judge is a gatekeeper. Unlike the federal counterpart of 404B, our case law has said that our version of 404B is a rule of exclusion, not inclusion.
Right.
And the gate here was just left open. And I couldn't find any example of financial crime evidence that was excluded. And the granular detail and the expansiveness of which everything under the sun was allowed is arguably problematic. Even the nature of the victims, there are many examples here, and I want you to respond, so I'll just share one. I think his name is Tony Satterfield.
Right.
was testifying. Well, we had to hear about the disabled brother. How is that relate to motive evidence? That appears to be that not only is he a thief with a motive for murder, he's a despicable, low-life character. I mean, the very evil that 404B is designed to prevent, and then ultimately 403 as the final safeguard.
Right. Well, first of all, I'll say that this was never argued nor presented as propensity evidence, and frankly, this court has recognized, and other courts have recognized, that the less likelihood of propensity when there's a vast difference between the type of 404 crime and the crime it issued. You know, once a stealing white-collar lawyer, always a wife and son murderer. That's never was the inference and all the rest of it. Satterfield was independently relevant, and we streamlined this inquiry intentionally, and the defense made their general objection to the 404, but never did, once we kind of crossed through that door. We presented all of that in camera, never made any specific, like, you know, limit this part, limit that part. We tried to streamline it all. The only reason Satterfield was a witness who testified specifically was because Satterfield was one of the factors in the gathering storm. Satterfield, of course, there had testified that Appellant had reached out to him and that he had reached out to Appellant in the months leading up to the murders, I think even in June of 2021, asking about the case and about the settlement. And Alec, of course, is lying to him and saying, yeah, I'm still working on the case, I'm still going. But the reality is that he stole almost $3.4 million and had spent it 2 years ago.
But what did one of the Satterfield children's status as mentally disabled have to do with any of that?
Well, I think the point of that was just sort of the background of how Alec had interacted with them and how this was a family that was close to him.
Did the fact that the young man was disabled add to the fact that he stole?
I think what it added to, again, was we had a witness who was testifying for independent purposes, and that was just a background fact of the pressures on Alec, because he had taken this family under his wing, a family who had one individual that he had told, I'm going to help you, I'm going to take care of you, one of whom had special needs. He had spent all of that money. They're asking questions about it.
The sympathy directed toward the victims of the crime is not related to the motive. If he's a thief, and that was the motive for doing it, this extraneous information that tugs at your heartstrings is not related to that. And like when I asked you the question earlier, you responded by immediately segueing back to the financial crime itself.
Right.
Not this extraneous stuff of every granular detail
Yes, sir.
of his acts of theft.
Right. And I will just say, in putting that in, that was just, we had a witness testifying, that was part of the background information that witness testified to, and that, again, it was part of his interactions with this family that was part of the pressures, one of a myriad of factors that were all coming to a head in June of 2021.
If you had condensed your theory of motive,
Right.
the whole gathering storm thing, down to the essentials and left out all the stuff that the Chief Justice and Justice James were talking about. In my view, you could have done that in about an hour and a half or 2 hours. You took 12 and a half hours to do it. So then you're taking that condensed version, you're presenting it to the judge to try to establish a logical connection. This is following up on something Justice Verdon asked, and also asked the same question of Jim Griffin.
Right.
What is the level of inquiry that the trial judge goes into to kind of get to the legitimacy of the theory of motive? Obviously, the jury would be the ultimate decision maker on that, but to what extent should the trial judge question whether it's a valid and legitimate theory of motive?
Well, I think that the words of the logical connection are there, and I think that as far as the trial and the clear and convincing nature of the evidence, but I think as long as it is a passable theory of motive, and that motive is logically connected to the underlying crime, then ultimately, as you say, it's for the
in all the cases that I think we've looked at this logical connection question, it's been either easy, yes, there's a logical connection, or easy, no, there's not one.
Right.
Here, it's not easy. It's debatable, right?
Your Honor, I would say, and if you'll permit me, I'll go through why these are all connected and why this is a unique situation, and it demands, it's a complicated situation, and I would submit demands a complicated analysis of the law. It's not the typical case where you have a one-off crime, a few hours. It's not Adams, right, where it's an armed robbery just a couple hours before and they're smoking crack and that sort of thing. This is a long, unbroken chain. And, Your Honor, you can't understand the boiling point, which was crucial to the state's motive. And I always say motive is not an element, but it's the only element. And particularly in a case like this, where it's the murder of a wife and son, it is what everyone wants to know. And there's no disconnect between someone having a financial motive for a crime. I mean, it's in the movies, it's in Fargo, it's in
I hadn't seen Fargo. Get to the point.
All right, yes, sir. All right, but I'm just saying this is in a number of movies. But let's look at why this is all interconnected. First of all, it's all interconnected, despite how temporal the temporal time period, because what's relevant to motive is what is in the appellant's mind. Okay, and what he knows is potentially going to be and is about to be exposed. And that's all of it. And frankly, it eventually was. So what is relevant is not, well, it was just yesterday or it was last week or it was a year ago. What is relevant is what does he know all is about to come out? And that's a decade of him constantly staying one step ahead of the game through one theft as another. And that brings up the second point, that this is all interconnected. It's an unbroken chain, and you can't truly understand, in what is crucial, motive, you can't truly understand the boiling point if you don't understand the slow burn leading up to that, okay? And the defense put motive in issue as their biggest thing was, frankly, character evidence of he's father of the year. There's no way he could have done this. So this, in the case law, says that where motive is a central issue like that, that there is a wider scope. But let's talk about it's interconnected. The jury could not understand the full weight of the pressures if they didn't understand that entire criminal and financial history. You can't understand the need for it without understanding the lifestyle, the bad real estate deals, the maxed out loans. You can't understand the Badger theft of over $1 million if you don't understand that they had, with his bank co-conspirator, had stolen $1 million from the Plier loans, and that had to be accounted for. You can't understand the need for fake forge and why he did that if you don't understand the complications of having to steal that $1 million.
I think all of that is completely accurate. Mm-hmm. The disconnect that the defense is getting at and that I'm trying to ask you about occurs when he takes the what the judge called some sort of urgency. He had a nice phrase he used when he was ruling on it. How do you get from that to murdering your wife and son? That's the disconnect that the defense is focusing on. They're not focused on the disconnect between forge and stealing money. That everybody understands that. And my question is, when analyzing that disconnect, what's the point of law? What's the rule of law that we look at, that the trial judge looks at?
Mm-hmm. Well, again, I think that the trial judge makes that determination of whether there's a logical connection and whether or not the evidence is clear and convincing. And I understand that under South Carolina there is a gatekeeping function that is there, but I think that as long as that
Let me throw out a couple of examples and I'm going to leave this alone. Mm-hmm. Obviously, you think there's a logical connection. Is that enough for the trial judge? Or does the trial judge have to decide for him or herself whether there's a logical connection? Or does the trial judge have to look at whether there's a reasonable possibility that the jury might find there's a logical connection?
I would assert that the trial judge should look to whether or not that is a reasonable inference from the evidence. And if it's a reasonable inference, and then it should go to the jury. I mean, that's what we do with all sorts of evidence, is determine whether or not there's a reasonable inference from this evidence. And if so, reasonable inferences are for the jury.
Can I follow up on that?
Yes, sir.
I think Justice Few wrote State versus Perry, and
I wrote 3/5 of it.
Yeah, it helps the Forrest Gump and me understand it. Mm-hmm. This 404B evidence. I am also struggling with the logical connection. Your brief is excellent, phenomenally done, but you say in the brief on page 87 that according to Perry, relevant is defined as evidence having a tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable, so forth and so on. You emphasize the word any. And what I fear is if we get on that train and emphasize the word any, that allows speculation to enter the room. Help me out with that, because I would accept, you emphasize in your brief, boat wreck, boat wreck, boat wreck. That's all Alec Murdaugh wanted to talk about when he was on video.
Right.
I get that. So I think there's clear evidence of motive for him perhaps to kill Paul, because this boat wreck case was becoming an anchor around his neck. And then you could stop right there or get into the boat wreck accusation more. But your emphasis of the word any, to piggyback on what Justice Few was saying, I'm struggling with the logical connection that comes from the word any. That means, it seems to me you're just saying whatever we say that makes sense, let's stick with it.
Well, by emphasizing that word, I don't think, and I'm not at all trying to assert that any sort of speculation would be sufficient. What I am saying is, again, the words logical connection. And I think that if it is a reasonable inference, as I just said, I'm not saying that the trial court should just entertain any speculation or any sort of fanciful thing that they come up with. I would, though, encourage y'all, though, to look, not only at the brief, but look at the filing that we did beforehand, and look at the PowerPoints and look at the closing argument, that, this is not just a speculative motive. This all ties together. And I had a whole series of how I could go through all of that, I think there's about 10 factors of all things that were all coming to a head, all of that gathering storm that were coming ahead to that day. And that ultimately this, if you're looking at the validity of this, it actually worked. It actually worked, because when all of this happened, Paul, who you just mentioned, had become that liability. Well, Maggie was too, okay? Her name was on Edisto. Her name was on Moselle. And he was at the end of his rope and unable to move like he needed to move financially, and out of options. He had burned through $792,000 in less than 2 months. And all of these things were coming to a head. But when this happened, everything changed. All of a sudden, he was the center of attention. All of a sudden, the sympathy factor kicked in. All the inquiries stopped, and the boat hearing stopped. The plaintiff in the boat hearing said, this has totally changed the balance of my case. And what did he set about doing? There was testimony that he wasn't overly concerned about Buster's security. He wasn't overly concerned about going after the real colors. But you know what he did do? He fixed the glitch. He fixed the glitch so that his lawyer friend would send back or at least send an email saying all the money's here, and put that to bed. So if we're looking for that logical connection, whatever standard is applied, this is not speculative. I understand that it can be hard to accept that. Why would somebody do this? But that's precisely why this motive evidence was so probative and so important. And even though this is a unique case and a unique, maybe lifetime set of facts that will never be seen again, that's all the more reason why this needed to be admitted, and for the jury to fully understand this unique individual from a unique background and a unique set of family circumstances and a unique lifestyle and a unique history that all was about to come unraveled. And that was more important to him than anything, and that when this action took place, not only did 2 of his liabilities go away, but all of those hounds at the gate went away as well. And if it wasn't for a check falling out of a file a few months later, it might have worked. It worked for a couple of months.
I got one more question to go back. What does it mean when something's not on his extraction?
It means that, the inference from that is that the user or someone deleted it.
Thank you.
I want to ask a question about tool mark.
Sure. Justice Few has a question, sir.
Yeah, I want to flip over to talk about the tool mark testimony by Mr. Greer. There are a lot of cases around the country that have held that this idea of examining shell casings for tool marks is a valid method in trying to determine which guns a cartridge was cycled through. In fact, I'm not aware of any that go to the other direction. So abstractly, it seems to me like it's a valid theory. Maybe not, I'm just setting that aside for purposes of my question. But our cases have required not only that the theory be valid in the abstract, but that the theory be reliably applied. Justice Hill wrote about this in Warner at the Court of Appeals. We decided a case called Galloway recently where we stressed it. And really, I think if you go all the way back to Watson, that's what the court was talking about. As I read this record, there's nothing, I mean, literally zero, about how Paul Greer used the method. He says he used it, but he didn't say, I found 4 different individual markings. He didn't say, here they are, here's where they were, nothing. And the thing that really troubles me about that is during the cross-examination by Mr. Griffin, I think this was in front of the jury, Mr. Griffin says, isn't your opinion in this case about the shell cartridges being fired from the same 300 blackout, isn't that based upon your presumption that each 300 blackout manufactured in the world makes unique tool marks when it cycles a bullet and ejects it? Now, that's a legit question. For a tool mark and firearms examiner, in my view of it, there's only one answer, and it only has one word. And the answer is yes. It's like DNA. If DNA is not different in every individual, then the fact that DNA, it would be of no use to anybody. Fingerprints are the same way. If fingerprints weren't unique to every individual, then we wouldn't have fingerprint evidence. We also don't have tool mark analysis of cycled gun cartridges unless each gun makes a unique individual mark, right?
Yes, sir.
So when you don't tell the jury anything about how Greer applied the method, and Greer mistakenly fails to discuss the central theory of the whole method, how have you demonstrated to the judge that the theory was validly and reliably applied in this case to these facts?
Yes, sir. Well, I think as we look at the specifics of the testimony, and I would start with, I think with this issue and frankly the TARP issue and the cell phone issue, that these are questions that go to weight, not admissibility. And I understand what you're saying.
That ain't what Judge Hill said in Warner or what this court said in Galloway.
Right.
That's not the law.
Right. Well, ultimately, I think that in this particular instance, if you look at the entirety of his testimony, he went through the acceptance generally of this for over 100 years. He went through the SLED procedures. He went through the acceptance and peer review in journals and the quality control procedures, the blind review. So while there may not have been a more specific explanation of that, the general discussion of the applicability and the reliability of the science was clearly in this record. And on top of that, I will also point to this that was in the record that shows that reliability. There's 2 things. Number 1 is that the examiner was able to distinguish between the cases around Maggie's body and the cases outside the gunroom door and the cases across the street and say that those were all cycled from the same weapon, but was able to distinguish those from matching it to the one blackout that was recovered, okay? And so that distinguishing right there shows an inherent reliability to the science. And on top of that, then another blind examiner came up with that same conclusion. So that ability that was in the record to separate the wheat from the chaff answers the question, even if it wasn't explicitly answered, as Your Honor points out.
Thank you for your answer.
All right. Mr. Waters, thank you so much. Appreciate your argument,
All
sir.
right. Thank you, Chief Justice and the court.
Mr. Barber, you're going to handle a reply.
Mr. Chief Justice, may it please the court?
Let me I want to ask you, because it's fresh, you don't get free minutes uninterrupted. I was listening very carefully to all the arguments. Mr. Waters was trying to defend the admissibility of the expansive nature of the 404B. And I thought he made a very compelling point, because one cannot fully understand, I think he used the word bowling point, without all of these interconnected parts. And so that's the logical connection that gives the judge the discretion to allow the fact finder to consider the evidence. So I'd like you to address that 404B issue, and particularly that position argued by the state.
Yes, Your Honor. I thought that the strongest point, really counter to that, was look at what was actually admitted. We had the victim impact testimony from the financial crimes, which I think the questions made clear have no connection. What did they connect to? Mr. Waters had a theme through his examination of all the witnesses. He asked every one of them, did you know the real Alec? Did you really know him? That was a question that was asked every single acquaintance. Did you really know him? You didn't really know him, did you? The theme there, clearly, was that you didn't really know. He's really capable of anything. He's a bad person. You don't know what he's capable of. And that's why that evidence was, that's why you had the mentally disabled, victim of a financial crime, which has nothing to do with the supposed motive of, I need to conceal something because I might get caught, right? It has to do with, you don't really know me. I'm a really bad person. And because you don't really know me, you don't know what I'm capable of, so please speculate that I'm capable of murdering my wife and my child. That was the purpose of that evidence. We didn't have, whatever it was, 12 days of financial crime testimony just to prove the fact that he stole a bunch of money and might possibly have had some fear that he might one day be caught for having stolen that money. And then the speculation is, well, he wanted a distraction, and we can talk about why this would, the logical leap to I'll just murder my family and be the center of attention, and how that's somehow going to get scrutiny off of me, obviously doesn't make a lot of sense. And I think he, more than most people, is in a position to know, given his background, that putting himself at the middle of a high-profile murder investigation is not the best way to distract attention from his own affairs. So I believe that's why that's the logical disconnect. And then the real reason that it's admitted is this trial theme that you'll see in every single witness who had a personal acquaintance with him. Every single one asked, did you know the real Alex Murdaugh? And that's why that was admitted.
Thank you, sir.
If I could, I would like to speak a little bit to the cell phone questions that both got, I believe, respectfully, maybe the factual predicate behind some of the questions might have been a little off. By way of very quick background, the iPhone has a database that records with a timestamp every time the screen lights up, every time it goes off. Various events will cause the screen to come on and off. An incoming phone call turns it on. It stays on for a period of time, it turns off. Incoming text messages, other kinds of alerts. And then there's this rise to wake feature, which is slight movement of picking up the phone causes it to come on and off. Now there's an entirely separate feature called an orientation change, which is it moves a different way enough to rotate the screen we've all seen from portrait to landscape. And that only happens if the screen's already lit. The importance of all this is Maggie's phone screen was lit continuously from about 9:02 to almost 9:07 p.m., right? So it's lit that whole time. It did not just suddenly light up at 9:06 and 12 seconds. At 9:06 and 12 seconds, what happened was the final orientation change, which was a process that took 8 seconds and ended at 9:06 and 20 seconds, right? And at that time, at that exact time, there was an incoming call from Alec Murdaugh. Right, so it's rotating, someone's rotating it while he's calling the phone. Her phone was lit up that whole first 5-6 minutes because he was called her phone, I believe, 3 times, texted 1 time. It stays on for a minute after, that's why it stayed on the whole time. So we it could have, if the issue is with the screen lit, it was lit at 9:04, 9:05, 9:06. So if throwing it out of the moving car causes the screen to light up, it could have been thrown out at any of those times. But it goes off before 9:08 and 20 seconds, which is when we now know, drove by the point where it was recovered. So the screen is off that whole time. It doesn't come on again until there's another call, 20 minutes later, right? So it's dark the whole time he passes it. So the issue is,
This is all directed at my questioning Mr. Griffin about the importance of the expert, of the testimony, the evidence.
yes, Your Honor, absolutely.
Your answer is that it's important if the murder occurred between 9:02 and 9:07. Why is it important if the murder occurred after 9:08?
Your Honor, it's not when the murder occurred, it's when, after the murders, when a phone is thrown to the side of the road.
Right, but the phone wouldn't have been thrown to the side of the road before the murder.
Correct. The point is that at the time that we know for certainty the defendant drove past where the phone was thrown, the screen never came on. There's a long period of time before that when the screen is on continuously.
You make a great point. If all this occurred before 9:07, then my questions to Mr. Griffith were, as you pointed out, factually flawed.
Mm-hmm.
But if it all occurred after 9:08, now you answer the question, because I think the validity of my question is now squarely on the table.
If your question is, could it have been thrown out after 9:08 p.m., then the answer would be that would be inconsistent with the screen not coming on, yes. The point is the phone had to be thrown out before he drove past that spot. And that fact was not known until near the close of the state's case, right? Because somebody at General Motors was watching the trial, saw when the FBI agent testified on cross that they don't cooperate with murder investigations. Somebody took exception to that, and they produced accurate data, to pretty much every 3 seconds, not from his vehicle, but from a server General Motors keeps, far away, tracking his every movement, even though it was years earlier. And so all of a sudden, we know exactly where he is and know with certainty it's to the second when he drives past that spot, and we know that the phone is dark the whole time. So the question becomes, is it possible to throw the phone out at that moment without the light coming on? And as Mr. Griffin said, we don't know how it got there. Somebody could have stopped the car and gently put it out, but we know he didn't do that. So that's the central question. And the testimony from the defense was, here's the feature, everyone can see it. I'm not qualified to say whether throwing it from a car will cause it to do whatever. And we had an accident reconstruction guy who was qualified to say that. But then the defense rebuttal expert, they bring in a chain of custody expert from their direct who says, well, I threw it around my office, no one saw me do it, but I'm here to offer you what Mr. Waters accurately described as an expert opinion, that if it's a gentle motion, this is what it does, but if it's a violent motion, this is what it does, and this is why it's programmed to do and behave in that fashion. That's clearly expert testimony. It was well beyond his expertise. He was offered as somebody who knows how to use Celebrite to download the extractions that we've been talking about. And as to the preservation, it was immediate objections as soon as this came out. The motion was renewed the first time the jury left the room. The judge ruled, Judge Newman ruled for the reasons he gave on the record, which we assign error to. It was not an untimeliness ruling. So I don't believe that there's merit to the preservation argument there. The judge even said that the objection was preserved for the record.
Is there any dispute that Mr. Murdaugh called 911 20 seconds after OnStar recorded that he arrived at the scene where the bodies were?
No, there's the timestamps that OnStar produced and the 911 timestamps are not in dispute. I would note that the nature, it's a rural area, and just because you first got there, it's dark. You don't necessarily immediately see someone the first second OnStar says that you pull up, and you've got to get out and look, and then his phone is connected to the Bluetooth,
Well, what do you say to the state's argument that that's not enough time for him to do what he said he did, which was go check on the bodies, which were 30 feet apart?
In 20 seconds, to look at two bodies that are 30 feet apart, I don't think that's impractical at all. I think I could If you think about a pace is about 3 feet. If you're alarmed, and you could take a pace in less than a second, right? That's not, you don't even have to break a run to do that.
Can you respond to Mr. Waters' comments or argument about the clerk of court?
Absolutely, Your Honor. I think the most important point to point out with that is that there was absolutely no finding by Judge Toll that Juror Z was dishonest. That is not a finding.
She said she was ambivalent.
Your Honor, she said that only as to her response to the question forbidden by 606B about the influence this had on her deliberations in the deliberation room. She said she was ambivalent, whether it was that or pressure from other jurors during deliberations. There was no question of her credibility when she was recounting what Clerk Hill said to her before deliberations began. None. The only evidence presented at that hearing, the only evidence contradicting anything Juror Z said or the alternate said or that was proffered by the egg juror in affidavit, the only evidence whatsoever was the testimony of Clerk of Court Becky Hill. It was not credible at the time, and it turns out that Judge Toll, was good at judging credibility because it has since come out that she perjured herself at that hearing when testifying about a different issue, but about her conduct at the trial. So she was, the testimony of a perjurer at that hearing, admitted perjurer, is the only evidence contradicting the statements, the sworn statements from Juror Z, from the alternate juror, from the sworn affidavit of the egg juror. So our position would be that it is would be wholly unsupported by the record to credit that denial from Clerk Hill over all the other evidence in the record. That would, if that finding were made, which the state argues was implicitly made, certainly wasn't explicitly made, that would be an abuse of discretion. However, we argue that that wasn't implicitly made because Judge Toll didn't reach these sort of almost nitpicking, was this said versus that said. She found that her word exactly was improper. Improper comments were made to the jury. She found that it was a deliberate attempt to influence the jury, that she had a book deal. That was all found. But it didn't matter whether it was this comment or that because her decision was controlled by an error of law, which was essentially that the defense had the burden to show some sort of but-for causation to the verdict. It didn't matter because it didn't affect the verdict. Whatever was said was improper, but the verdict would have been the same no matter what. That's the written order. And that is the error of law because the prejudice, which has to be shown, is the prejudice to the fair trial, which is that these things were said to the jurors, right? That's the bias, right? This was said to the juror. That's the bias. We've shown the prejudice when we've shown that it's been said to the juror because now we don't have an impartial jury. There's no need to show the effect of the bias on the verdict.
But he says the comments were fleeting and innocuous. And Judge Toll said limited in subject and not overt as to opinion.
Yes, Your Honor, and maybe to address a question I was asked at the very beginning, is that a question of fact or law? What was said, that's a compound question. What was said is a question of fact. Characterizing it as an application of law to fact is a mixed question. To the extent you have to disaggregate it and say, well, what was said? Again, the only evidence in the record, right, unless you were to accept the found to be not credible testimony of Clerk Hill, who's also perjured herself, the only evidence in the record is that those don't believe the defense was said. Don't be fooled by the defense. That's the evidence in the record. All right, so given that said, to characterize that as neutral as to opinion is an abuse of discretion, and it is a misapplication of law to those facts. To find that that wasn't said would also be an abuse of discretion because it would be a finding wholly unsupported by the record.
Maybe one? Yeah. I'm just going to remark that it's not fair to you and Mr. Waters that y'all had to talk about every issue and these other two deadbeats over here only had to talk about half of them. But are you good to talk a little bit about some of the real nuances of the tool mark?
Absolutely, Your Honor.
Okay. You put in the pretrial hearing, or Mr. Griffin did, the theory of tool mark is set forth in several documents that have been widely circulated and published by the AFT and so forth. But there have been criticisms of those, and one of the most striking ones is this idea that the conclusion, how they reach a conclusion, is circular, and that makes some sense, really. But my question to you is, wouldn't you say that those criticisms go more to the application of the theory than they do to the validity of the theory?
Yes, Your Honor, if I could. It's important to, I think the best way to look at it is to compare it to DNA evidence because it's so striking, right? Everything in the universe is unique, right? The tool marks are all unique. The question is, do we have a process that can reliably distinguish, the cause of this mark to the exclusion of all others, right? That's the actual question. I did this process, and I can say, with some degree of certainty that, these two tool marks are made by the same weapon and not two different weapons.
To shorten it up, I'm suggesting that you just asked a really good question. Do we have a process to differentiate? And I'm suggesting that these criticisms that have been published, particularly this idea of the circular thing, would answer that question. Yes, we have a process, and it works, it's valid, but it has to be meticulously applied. Is that a fair way of interpreting those criticisms?
It's certainly fair. Where I was trying to go with that is with DNA evidence, as the court knows from the many DNA cases that it's had recently, these differences are quantified, and you get a very, 1 in 8 billion or whatever chance that these, came from different people that we say it's a match, right? Here, you have this very circular and very subjective. What you have in the end is two marks that look really similar, and somebody eyeballs them and makes a subjective judgment call that these two look really similar. And our basis for that is circular because we say, well, I look at this part and that part, and it's like, well, how do you know that means they're the same? Well, that's what we've always done. That's what I was trained to do, and it's very circular.
The theory says you have to find whether they match. And the next question is, well, how do you know that? And you say you have to find sufficient alignment. And,
Right.
Nobody ever comes down with a hard rule like you got to find 5 marks on the same cartridge that are identical to the 5 marks on this cartridge. Whereas with DNA, particularly with the ideas like touch DNA, you have the expert saying, I was able to identify 8 pairs of chromosomes and they match to what was at the crime scene or to what we found from the defendant, and that gives a 1 in 1 million chance that it is somebody else.
And to do anything like that with tool mark, you would have to quantify the similarity and differences of the tool marks.
And that's what I'm getting at, is all of that goes to the application of the theory, I think, not to the abstract validity of the theory.
Absolutely, and there could be a day that with computers or AI that you can quantify and do something differently. But right now, having somebody eyeball it and say they look pretty similar to me, I think they're the same, that's not a reliable application of the theory. It's totally subjective. It's not quantified in any way, and it's certainly not something that could be subject to any sort of
I wasn't trying to get you to concede that the theory is valid. I was really just trying to focus in on the importance of an explanation of how the theory is applied in an individual case. Thank you.
No further questions?
Hearing no other questions, Mr. Barber, thank you so much. And I
Thank you, Your
speak
Honor.
on behalf of the entire court. I want to commend excellent counsel on both sides. Thorough, detailed briefs, very helpful to the court and its staff. That is combined with arguments that reflected a commendable command of this lengthy and complex record, together with applicable law. And it has all resulted in excellent arguments today. You've represented your respective positions professionally, and we all on the court commend counsel for both sides. We are adjourned.